Let me state here and now that the National Democratic Congress stands with Dr. Ayene against what is increasingly becoming a campaign of judicial tyranny being waged by no less a person than the Chief Justice of the Republic against lawyers who identify with the NDC. Indeed, the latest persecution of Dr. Ayene is part of a grand agenda by the current Chief Justice to intimidate, cower, and muzzle all dissenting voices, particularly those in the NDC, who dare to speak against some of the strange decisions that characterize the 2020 presidential election petition. As you may be aware, only a few months ago, some lawyers with NDC leanings, specifically lawyer Abraham Amaliba and lawyer David Anan, were hauled to this same disciplinary committee of the General Legal Council by the same Chief Justice in similar fashion and harassed for expressing their views on the constitution of the Supreme Court panel that heard the 2020 election petition. Also, not long ago, the Honorable Roxanne Nelson K. Eche Dafiamapo, the NDC Member of Parliament for South-Dine, received a similar invitation to appear before the disciplinary committee of the General Legal Council. Ladies and gentlemen of the media, Dr. Ayene spoke at a roundtable discussion which had other lawyers and academics brought together to analyze the impact of presidential election petitions on our democracy. When the question about confidence in the independence of the judiciary was posed, lawyer Yao Opong, a member of President Akufo-Addo's legal team, responded that he thought Ghana's judiciary was independent. Dr. Ayene, on his part, expressed the view that his confidence in the independence of the judiciary has been dampened by the way the court determines some of the interlocutory applications of the petitioner without due regard to judicial precedents and settled rules and practices. Ladies and gentlemen of the media, the way in which the Supreme Court, in the hearing of the 2020 election petition, continuously shielded the chairperson of the Electoral Commission, Mrs. Jean Adukoya-Mensah, from scrutiny and accountability, has been the subject of critical comment by many people. Indeed, much of the criticism has been from people who are in no way associated with the National Democratic Congress. We must say we are also struck by how positions that the current Chief Justice took in the 2012 election petition are completely opposite to his positions in the 2020 election petition. And we may ask, what has changed? Let me read to you a few sentences from Justice of the Supreme Court, as he then was, Anin Yeboah, when he dissented in respect of a ruling concerning whether the Electoral Commission should be ordered to produce certain documents. He said, and I quote, "In a serious matter in which the mandate of the entire voters of this country is being questioned through the judicial process, one expected the second respondent, as the sole body responsible for the conduct of elections, to have exhibited utmost degree of candor to assist the court in arriving at the truth. Surprisingly, the second respondent, Electoral Commission, opted for filing no pink sheets, leaving this court unassisted and thereby placing reliance only on the pink sheets supplied to the agents of the petitioners at the various polling stations in issue. While the second respondent elected to deny assistance to a court of law in search of the truth in a monumental case of this nature is beyond my comprehension." He continued, "I think this must be deprecated in view of the constitutional autonomy granted to it to perform such vital functions under the Constitution for the advancement of our democratic governance, unquote. And that was Justice Anin Yeboah in 2013. Yet, in the recent election petition, the same Chief Justice, Anin Yeboah, dismissed every single application on behalf of the petitioner to have the chairperson of the Electoral Commission, the same Electoral Commission, assist the court to establish the same truth. In 2013, Dr. Farijan went into the witness box and was subjected to extensive cross-examination. That was not enough for Justice Anin Yeboah then. This time, Mrs. Jean Mensah, having sworn to a witness statement and sworn to affidavits to the effect that she would be available for cross-examination, chose not to testify. Even an attempt to reopen the case of the petitioner to enable her be subpoenaed was rejected by the same Chief Justice and his colleagues. Why was the conduct of Mrs. Jean Mensah not deprecated this time around? How does the Chief Justice, Justice Anin Yeboah, expect Ghanaians to have confidence in his impartiality and fair-mindedness as a judge in the face of these contradictory decisions by him? Also, the way and manner the Supreme Court unanimously dismissed virtually all the interlocutory applications of the petitioner without regard for the law, in some instances, further dampened our hopes in that important arm of government. You may recall, for instance, that in their ruling on the application by the petitioner to reopen his case to call the EC chairperson as an adverse witness, the Supreme Court disregarded the clear provisions of the Evidence Act of Ghana, which is the law in Ghana, and opted for a wrong interpretation of the Black Law Dictionary of UK. Black Law Dictionary's definition of adverse witness. We all know that where the law does not explicitly provide for any subject, you may borrow from other jurisdictions, but clearly not where your law states clearly what should operate in Ghana. You abandon that one and you go looking for advice from dictionaries elsewhere. In that ruling, the court said that a person cannot be an adverse witness until he has already mounted the witness box, despite the clear provisions of the Evidence Act of Ghana, which provides that in a civil action, a party or a person whose relationship to a party makes the interests of that person substantially the same as a party may be called by an adverse party and examined as if on cross-examination at any time during the presentation of evidence by the party calling the witness. When the petitioner applied for a review of this decision, and the court was presented with a golden opportunity to correct this clear error of law, the court refused to do so without any plausible reason. How then can anybody fault Dr. Ayine for saying that his hopes about the independence of the judiciary was dampened by the way and manner the court failed to apply the law and judicial precedents in dealing with some interlocutory applications of the petitioner? Friends from the media, our position on this matter is simple. Dr. Ayine's views about the independence of the judiciary are views he is entitled to, in line with his freedom of expression guaranteed under the 1992 Constitution. He was courteous to the court and kept his language temperate and decent. He stayed within the bounds of professionalism. He was neither scurrilous nor scandalous. For him to be accused by the Chief Justice of disparaging Ghana's judiciary over these tempered and justified comments is not only bizarre and unfortunate, but speaks volumes about the Chief Justice himself. Clearly, the opinion expressed by Dr. Ayene, which we in the NDC share without any equivocation, is not actionable and does not violate any rule of professional conduct for lawyers. As a matter of fact, neither Dr. Ayene nor we in NDC can be compelled, and I repeat, can be compelled to increase our confidence in the independence of the judiciary, even when the court has not given us any basis or reason so to do. The Chief Justice ought to be reminded that according to Article 125 of our Constitution, justice emanates from the people and is administered on behalf of the Republic by the judiciary, which shall be independent. Public confidence in the independence of the judiciary must therefore be earned and not be forced on us. Nobody can force anybody to have confidence in a system that does not justify that confidence. It is naturally not possible. So if you want me to have confidence in you, you must demonstrate by your actions that you deserve that confidence. I cannot be compelled by any dictator to have confidence in anything that I don't have confidence in. Ladies and gentlemen of the media, we are concerned at the seeming judicial dictatorship that is fast festering under the leadership of the current Chief Justice. An unwelcome development which threatens free speech and could potentially undermine our justice system. You will recall that not so long ago, and immediately before the judgment on the elections petition was pronounced, the Chief Justice instructed his private lawyer, Mr. Teddy Usori, to issue a threatening letter to media houses in the country, ostensibly to restrict public criticism of the court on grounds that the Ghanaian people are uneducated and uninformed about legal issues. When there was public uproar, it was then claimed that the letter was not aimed at preventing criticism of decisions of the Supreme Court in the media. So you see how it proceeded. You were going to announce a verdict. For some reason, you yourself took the position that that verdict will be criticized. And so you issue a warning that no media house should criticize you because we are all not learned in the law. How many times have you seen any court or heard any court telling anybody that I am going to give a judgment, but I'm warning you not to talk about the judgment? So what does it tell you about your own belief in the judgment you are going to deliver? Why are you not expecting that after delivering the judgment, all the media houses will be praising you for doing a good job? Why didn't you think like that? And you simply assume that they will be criticizing me. So it means that that is an admission that what you are about to do was wrong. And it didn't end there. Now you have done it. And we are talking about it, and you say we cannot talk about it.